I would like to welcome everyone to part two of the ADA webinar series, Reasonable Accommodations, Auxiliary Aids and Services. Our guest presenter today is Mr. Diego DeMaya, and he is with the Southwest ADA Center. And I also would like to introduce Marissa DeMaya, who also works. And I believe Marissa will unmute, and she's going to take it away.
Thank you, Anne-Marie. Hi, everyone. As Anne-Marie mentioned, my name is Marissa DeMaya, and I'm with the Southwest ADA Center here in Houston. We are one of 10 centers that is federally funded to provide you with free, I like to say that word a lot, information and resources and guidance on all things related to the Americans with Disabilities Act. Again, as I said, we're one of 10 centers across the country who do this. We don't just cover the state of Texas. We actually cover the Southwest region, which includes Oklahoma, Louisiana, New Mexico, Arkansas. Did I miss any of those? I don't think I did. Anyway, we're one of 10 centers, and our region is pretty wide there. So anyway, what you can do is if you do have questions that you don't feel comfortable asking at any point in time during this presentation, you can always call us. We have a toll-free line that people can call, and I will put it in that chat area in just a second. But if you'd like to take the number down, and we're probably going to shamelessly plug it throughout the presentation, it is 1-800-949-4232. Okay? I will put that in the chat area here as soon as I finish up. So I'm going to not delay any longer. I'm going to kick it off to my favorite trainer, Diego DeMaya. Diego is our lead trainer here at the ADA Center. He's also the technical or lead technical assistance provider here. So if you call that line, chances are you will get Diego probably a good percentage of the time. You can also shoot him an email, and we've included his contact information at the end of the presentation, so you can do that if you want to talk to him more one-on-one. Diego has been with the center, just very briefly. He's been with our center for about 15 years, providing training and technical assistance to numerous organizations and individuals. And I'm just going to go ahead and kick it off and turn it over to him. Diego?
I can't believe I've been here for 15 years. Okay, I'm going. That's it. I've had enough. But no, I'm just kidding, folks. Okay, so I want to acknowledge, thank you, Anne-Marie, for introducing and also doing all the technical aspects of carrying this project, and making it happen. And I certainly appreciate everyone listening and their respective entities and the people they work for tuning in and listening or calling us and asking questions. We're more than happy to share everything we know and have about the ADA. And I also want to mention that Marissa stole my last name, and we're trying to figure out how to debate that issue. But we're kind of working it out, But anyway, just thought I'd mention that she happens to be my sister as well. Anyhow, with all that being said, let me get started here right away. We have quite a bit of ground to cover. It's not so much that the material is dense, but rather that I definitely want to remind people that no one is required to memorize all this stuff. I mean, anyone who can memorize all this stuff is by far a superhuman, and they shouldn't be listening to this webinar in that case. But nonetheless, sometimes attorneys ask other attorneys, legal questions, and and they'll respond with, "I don't remember that. I don't know what that, what the definition of that is or what the regulation says." And the reason is because it's better for us to learn where to look things up and to learn, to find out where we can find that information and get the answers we want, get the understanding that we want. So this is why the ADA Center is here. This is why I plug our website, which is southwestada.org, and you can go there and research our easy-to-read disability law index, for instance, where you can look up the regulations by topic, the statute and regulations by topic. Whether you're inquiring about, or researching Title II of the ADA for public entities, local and state government entities like a college or a university, or whether you're researching Title III public accommodations, or otherwise known as nonprofit businesses or profit businesses and private organizations. Okay, so in getting started on slide 7, I do believe, we are reviewing the ADA, just to kind of, do a quick review that the ADA generally requires that services, educational programs, classes, and services provided by both public entities as well as public accommodations, that they make them ADA accessible, and that's kind of a general term there. But I want to mention a couple of things on this slide. So, for example, in 2008, the ADA was amended, and Congress basically revised a couple of important things under the ADA. And one of the key things to remember that was revised and changed was that it made the definition of disability broader. So it encompasses a lot more individuals with certain types of disabilities that before 2008 might have not been deemed as covered either by a court or even by an entity based on what they were disclosing in terms of a disability. And so the definition of disability has gotten broader, and we will kind of go over that in a moment. But in a nutshell, what you need to understand is that it's very, very likely that you will, as teachers who teach classes in any type of environment, whether it's college level or adult literacy level, you are bound to be receiving many more requests for accommodations by participants, or by students, okay? And then the other thing is that's really important to know about the ADA Amendments Act, and again, you don't have to remember this, but what you have to remember that the law has changed and been revised. The other change has to do with the fact that Congress, based on what it saw in the arena of court litigation under the ADA, what it saw is that what it did is basically it shifted the burden of proof back to the entity as opposed to the person with a disability. And so what happens now is that before it used to be, let me explain this. Before it used to be that a person with a disability had to prove that they had a disability and that they were entitled to reasonable accommodations, just to keep it kind of simple, okay? After the ADA Amendments Act, the burden of proof changed over to the entity providing the services or educational program. And basically that means that the entity has to show proof. And we're talking, court litigation now, okay? So keep that clear that this is things that happen when you go to court. And but just so that people understand how things changed, the burden of proof has gone back to the entity providing the service or teaching the class, meaning that they have to be able to show that they made a good faith effort to reasonably accommodate an individual who made a request for an accommodation. And the reason why that's important is because in the court litigation cases that one would go and read and research, you start realizing that the courts, before the 2008 amendments, the courts would essentially look at the technicalities of how things played out, and they would realize that the individual simply had not proven that they had a disability all that well, and they would essentially throw a case out, regardless of the merits of the case. It could be something as simple as a missing doctor's note, which, given time would have been obtainable somehow. And so what it is about now is that basically whether we're talking about a school or an employer dealing with employees with disabilities, or whether we're talking about a school dealing with students with disabilities, they have to show that they made a good faith effort in reasonably accommodating the student or the employee while medical documentation was being obtained, if indeed it was necessary. Because remember that typically medical documentation is permissible. A request for medical documentation is permissible, rather, when the disability of the person is a hidden disability. In other words, it is not easily observable. You can't see it. And so it's permissible for you to request medical documentation. An example of that would be a person who has a reading disability, such as dyslexia, which prevents a person from being able to read printed text. Obviously, if a person is in a wheelchair, then it's kind of, pointless to ask for medical documentation when you can see the person ambulating in a wheelchair. So what this means and boils down to, as we move on to the next slide, is that the entity has an obligation to accommodate first and then deal with the paperwork and documentation afterwards. The point becomes not to delay the process, but rather accommodate as appropriately as possible, and then move on with the accommodations process and the interactive process, so that people can talk to one another and figure out what reasonable accommodations would be appropriate for a student in the case of talking about classes or attending classes. So slide 8 basically talks about what Title II covers. Title II covers public entities, of course. And, that means local governments and their instrumentalities, which can include, anything from the mayor's office of a local town to the fire department to the police department and a local public school. So Title II covers all of these types of public entities. That's fairly simple, fairly straightforward. And it basically, says that all of their activities are covered, whether it's providing educational classes, providing adult literacy classes, providing workshops on learning how to read music, anything will be covered by Title II of the ADA, meaning that they would have to provide accommodations as well as making the entire program itself generally accessible for people with disabilities to be able to attend or participate. So moving on to the next slide, slide 9, I believe, what we have, essentially again talking about how public entities, may not refuse people with disabilities to participate. They have to provide programs and services in an integrated setting, meaning that they don't want to be engaging in a situation where they're segregating, they're separating out people with disabilities from participating in the main program that everyone else gets to participate in, or at the location or the site, for that matter. So that if a site isn't accessible, then the public entity would have to come up with some alternate way to present the program or to teach the class and make it accessible, make it available for people with disabilities to participate. Now, it is perfectly allowed under the ADA to have special facilities for people with disabilities to go to. I'll give you an example of that. In the city of Houston, for example, Houston has a place called a multi-service center for people with disabilities. It is essentially a place where people can go, people with disabilities, such as people with spinal cord injuries or other kinds of disabilities, as well as the elderly can go, and at no cost they can use swimming pool facilities. So, for example, they have a fully accessible Olympic-sized swimming pool where you can actually use a waterproof wheelchair and wheel yourself down a ramp all the way into the swimming pool. They also have a basketball court for people to do sports, and play basketball and other sports. They have a gymnasium, and they carry out many, many other types of activities specifically aimed at people with disabilities and bringing the community of people with disabilities together, for various events. So, for example, they also do voting there. They are, when it comes time for elections, they do voting at this location as well. So you can imagine it's a very, very accessible site on all facets of city programming, services, classes, workshops that take place there. But again, remember that an individual with disability essentially has the right to go and participate in programs offered at other multi-service centers throughout the city that are not going to be as highly accessible as the one that I just described. Because Houston and Harris County, for example, they have other multi-service centers for the public to go to where people don't have to have a disability. They can just go and participate in various community activities. But again, those sites have to be generally accessible, and the programs held there have to be also generally accessible. Again, meaning that if something supposed to offer a class and you get a student with a disability who wants to participate in the class, well, then they would have to accommodate that student at that location for that class. If the city can cite that providing the requested accommodation would be an undue burden, a financial hardship on its operations, then they would be able, in the case of Houston, they would be able to recommend that the individual go to this other, much more fully accessible location, provided, of course, that the same program is being offered there as well. So just giving you some examples of how some of these things work. So going to the next slide, slide 10. Again, I've been talking about this, practices, procedures. Public entities have to make accommodations. They have to be willing to make policy modifications. Policies, keep this general rule of thumb in mind, that policies must always be flexible. There's no such thing as an inflexible, strict policy. The only time that a strict policy can be enforced and not be deemed as discriminatory, in other words, that it would exclude someone with a disability, would be if the policy is necessary to maintain safety. It's necessary for a person to get a license. So for example, a blind person could not force the Department of Public Safety to waive its requirements to apply for a driver's license. I mean, that's an obvious example, but that's kind of what I'm saying, that the policy is perfectly legal for it to be strict and not permit someone who does not meet the eligibility criteria in order to apply for a driver's license. Okay. So again, they must furnish auxiliary aids and services to accommodate individuals. Now, auxiliary aids and services is something that we're going to focus kind of heavily because that has to do with communication type of accommodations. These are accommodations that deal with communication between and among individuals. So people who have sensory communications, for example, are unable to speak, speech impediment, people who are deaf or hard of hearing, people who are blind or visually impaired, or have sensory deprivation types of disabilities, and they would be, in most cases, they usually disclose having a disability. They come forward and request, as a reasonable accommodation, they'll request some kind of an auxiliary aid or service. For a deaf person, that could be an American Sign Language interpreter. For a visually impaired person, that could be a reader or assistance to fill out a form, for example. Okay. To the next slide. I think, I mentioned, providing qualified interpreters for people who are deaf or hard of hearing. And I'll talk more about that later, because there's some intricacies that I think people need to know about in terms of providing accommodations. But one important thing here, let's see here. One important thing is that, is the cost of accommodations, including auxiliary aids and services. And so, in other words, the public entity may not impose a cost or a fee or a surcharge, as it is referred to in the regulation. So no surcharges for providing reasonable accommodations in most cases of any kind. And that, of course, is going to be the same rule for Title III private entities. Again, they cannot assess surcharges for providing reasonable accommodations. And I think we're going to have an illustration that we can talk about on this.
Diego, just to give
yes.
you an idea, we're about 25, 26 minutes in, okay?
Okay, great, thank you. So moving on to the next slide, where we talk about, we review a little bit of Title III. What we have is basically, again, think of it as the same requirements as those applicable to Title II. The only difference is that Title II entities have a programmatic obligation to make programs accessible. And a program can be a program that offers a license or a certification, such as becoming a lifeguard. Okay, those are programs that the city offers. In other words, you go and take their training course, and then you get a license or a certificate. So they have to make all of those programs generally accessible, and that means that not every single location has to become accessible. That means that they could have certain sites where the program may not necessarily be accessible, but then it'll be accessible elsewhere at a different location, so long as it doesn't impose an extreme level of inconvenience for the person, for the applicant. So, for instance, if a city says, we don't have this course in an accessible format offered within the county limits, and then the applicant would have to go to a different county to apply for the service or the certification, that would not be lawful. That would violate the ADA, okay? Because it is not providing the same service that everybody else is entitled to. So, in other words, the inability for a Title II public entity to provide an accommodation would have to be based on, significant undue burden or financial hardship, as well as that providing the accommodation, and they would have to prove this, that providing a requested accommodation would be a fundamental alteration of the program. And we'll talk more about that later. Going on to the next slide. Again, we have the general requirements for Title III. And, I'm not going to go over this. Part of the reason why some of these slides are so dense is because I wanted you to have access to the PowerPoint and use it as an outline to guide yourself when you want to, have a quick access, a ready access to understanding ADA requirements and obligations. Moving on to the next slide, slide 14, I believe. It's important to keep in mind that the state public entity and a Title III public accommodation, a private organization or a private business, there will be a tension between the two if they form a relationship of some kind. And by relationship, we're talking about a contract relationship or, for example, a grant relationship. So, for instance, if a public entity, a state or local government agency gives a grant and private entities get to apply for the grant and, facilitate an educational program such as adult literacy, for example, then there is a connection there. There's a relationship being created. And that means that the public entity is entitled to impose stricter ADA requirements on how those funds will be used by the private entity. So I just want the people to understand that, and I think that, this is pretty clear from reading this slide. So I'm not going to dwell on it too long, except to say that, when a private entity indeed faces undue hardship, undue burden, or a fundamental alteration when it gets a request for an accommodation, then it needs to very carefully sit down and very carefully document what the problem is should the accommodation be provided, what undue burden will be caused, what fundamental alteration would occur if the accommodation requested were to be provided. And then they need to go and engage with the public entity who gave them the grant or the contract and discuss it with them to straighten out how to best accommodate people with disabilities at the given location or in regard to the given educational program. Okay? So once again, these are matters that are not etched in stone, and they are, there's no yes or there's no right or wrong answer ever to any of these types of issues that relate to the relationship between, or I should say, the ADA relationship between a public entity and a private entity. And also, of course, if you come up with any questions concerning this, and they would tend to be more policy questions about policy, you're welcome to call us through our 800 number and then talk to us directly or send us an email. Moving on to the next slide, I think is time for questions if we have any.
Okay, we haven't seen any questions come through. Anne-Marie, do you guys have anything that anybody have questions at this time?
No, I don't see any questions, but I want to remind everybody that Diego did spend a lot of time on the introduction of the ADA, and I know that I had gotten questions, emails about reviewing that. So before we move on, are there any questions that you'd like to have covered, as Marissa's saying? Just go ahead and put them in the chat pod. And it does take a little time for the questions to come up, so we'll just watch and see.
That's fine. Then maybe if you want to, we can keep moving if you want.
Oh, well, looks like we got one.
We do have one. We do have one. Marissa, do you want to?
Sure. They're asking, what determines undue burden? Can you elaborate more on that?
Yes, but actually I would like the person to hold that question because we're going to be discussing it in detail coming up in the next couple of slides. So if they're willing to wait on that, we're going to engage directly because the undue burden standard applies to both public entities as well as private entities. It's basically a significant financial hardship, but we will be talking about it.
Okay, I think we are good to move forward then.
Okay. So slide 16, who's protected? So what we have here is, the definition of disability. A person has a disability if they have a physical or mental impairment that substantially limits one or more major life activities, or they have a record of having had a disability, or they are regarded by other individuals as having a disability, even though they may not have one. Why is this important? This is important because first you have the definition of what is a person with a disability who presently has a disability and might be willing to disclose the disability to request an accommodation. So a physical or mental impairment, I think those words are pretty obvious in terms of meaning. And again, the impairments have to substantially affect a major life activity. So for example, it would affect the ability to walk, stand, hold things, having the use of your hands, vision impairments, being blind, people who are deaf or hard of hearing. All of these are substantial physical, these are substantial limitations on major life activities. Okay, and so we go to the next slide. This is important. Slide 17. A qualified individual with a disability. So what you have here is that a person with a disability has to be, quote unquote, qualified or eligible to participate for our example, in an adult literacy program. Okay? So in other words, they have to meet the eligibility criteria set by the educational program, by the school, by the people who are putting the program together and making it happen, making it available. So they're going to have eligibility criteria. Just like when we apply to go to college, you have to take entrance examinations and so forth. Just like when we apply for a driver's license, the same thing. We have to meet eligibility criteria, and this is going to apply regardless of whether we have a disability or not. So the reason why the ADA makes a definition of it is because they want people to understand, people with disabilities and without disabilities, they want people to understand that even a person with a disability still has to be qualified to participate in the program. The next slide, slide 18, we have examples of disabilities. As you can see, the list is non-exhaustive. In other words, it can go on and on forever. We can keep talking about and coming up with different types of conditions that would substantially limit one or more major life activities in a person's life. And so a disability can come in very different colors and shapes and duration even. A disability can be remissive. I bet people can think of many examples of a remissive type of disability or medical condition. A few come to mind. Cancer, people who have diabetes, people who have MS, people who have other types of conditions, people with HIV, for example. So there are medical conditions that will automatically be deemed as disabilities, and because they can come and go. The adverse physical manifestations of a medical condition will come and go, and they can be. The condition can be exacerbated by environmental, situations or other situations, and so people will have a condition that will become exacerbated and require reasonable accommodation if they are participating in attending classes. Okay, so just keep in mind there are many disabilities. Next slide. Slide 19. And this is the slide about reasonable accommodations. I think that people, for the most part, realize by now what a reasonable accommodation is. In other words, it can involve a different host of types of modifications to the program or to the education or to the class being taught. It can be an accommodation by a blind or a visually impaired person asking to be allowed to use a digital voice recorder to record class lectures. It can be a request to modify testing policies. So, for example, a person might need additional testing time. That would be a modification of the testing policy. Whereas everybody typically gets, let's say, 1 hour to take a test, a person with a disability might be requesting 90 minutes, or perhaps, time and a half, or perhaps 2 hours. So it depends entirely on the person's disability and the functional limitations imposed by the disability. Remember, functional limitations are going to be caused by the person's disability. So the question would be, what are they? What are those functional limitations? You would get to ask that question if a student discloses having a disability. It says, I need an accommodation. Then, typically you would say, what limitations do you have? What functional limitations do you have? Especially if it's a hidden disability, such as a person that, has dyslexia, for instance, because I know people who are dyslexic and yet drive automobiles and have jobs where they have to drive for a living. So it obviously doesn't affect the ability to drive. They have good eyesight, but they may be unable to read certain characters on text, or even be entirely unable to read printed text. Other forms of learning disabilities could be in place. They could have dyscalculia, where people have a difficult time reading numbers and understanding numbers. So again, accommodations can come in different forms. Next slide. This is an example of the types of reasonable accommodations that you might come across. And it's important, again, keep in mind, it could be just about anything you can imagine. And I'm saying that because we live in a world of advancing technologies. Technologies change just about every 2 or 3 months now. And every day, every month, every year, there are new things that people with disabilities can use or purchase that allow them to become more equalized. You can put it that way, more equalized with their peers in terms of their disabilities and the functional limitations that they face on a daily basis. The challenges that come with that. So, again, just some examples for you to have an idea. Next slide. This is really important. It's important to understand that whether it's a public entity or a private public accommodation providing the educational classes, the accommodations requested or that will be provided for the individual have to be appropriate. An individual with a disability is entitled to appropriate accommodations, not best accommodations. Okay? There's always going to be a situation where there's a preference for the best and most expensive or more lavish type of equipment or adaptive devices and so forth. But that's not the case under the ADA law itself. The ADA law simply says that the person is entitled to get reasonable accommodations that are appropriate in relation to the functional limitations imposed by their disability. Okay, so an example of this would be that many colleges and universities make it a routine to own digital audio recording devices now, because many students with vision impairments, whether low vision or blind, are going to at some point come to the Disability Services Office and request to be allowed to record lectures in the classroom. And to do that, you need some kind of recorder, preferably a digital recorder that allows you to index as you're listening to the recording. So you see, when I say the word adaptive devices, it really does mean in connection to people with disabilities, because a lot of these recorders have gone so far in terms of advancement that they allow you to index, when you're recording, so you can put tones in there, or you can actually mark the recording. Remember, it's all digital. So these are little handheld computers that allow you to do all kinds of things with audio nowadays, even translate audio into text in some cases. So there's all kinds of adaptive technologies available for people with all kinds of disabilities. And just to be aware, that the accommodations have to be appropriate, not best. So if the public entity or the private nonprofit organization teaching the class can provide an accommodation, an appropriate accommodation that will reasonably accommodate the individual and allow them to participate, then they are within their purview to provide that accommodation and make that available. But they don't have to go beyond that and provide something more expensive or more costly based on the preference of an individual. The next slide is about the preferences of the individual with a disability when they request an accommodation. And the important item to keep in mind here is that people with disabilities have, they have in-depth knowledge of their disability. They know what's best for them. They know how to study. They have learned, the ropes of having a disability and dealing with the limitations that they face on a daily basis. And so they're certainly going to come with preferences as to how they prefer to study, or how they prefer to read, or how they prefer to travel. Okay? Again, the entities are only required to provide appropriate accommodations, not best. So that means that there will be an interactive process between the two, and there will be a discussion that's required. So remember that providing an accommodation cannot be a one-sided avenue, okay? It can't just be that somebody says, oh yeah, we'll provide the person with time and a half to take the test like we do everybody else. That's not permissible. And the reason is because time and a half could be an inappropriate accommodation. It may not be enough time for a person, or who knows, it might be too much time based on the person's preferences. So this is why it's important to engage with the person individually on a case-by-case basis. That's what the ADA requires for accommodations, and discuss with the person directly. I always recommend that teachers engage the person in private and not in front of other students or other people, milling about. Okay, so I would not encourage having this kind of conversation like in a hallway of a school where people are going back and forth, coming and going. Try to do this in a private setting, even if it's just a classroom after everybody has left. Then that becomes a private setting to have this discussion and talk about what kinds of accommodations the person might be asking and what could be provided. Okay, and remember, there will be situations where some people with disabilities might know they have a disability, but they may not necessarily be terribly experienced at either requesting accommodations or even knowing what they need to participate in a class. So this will be a brainstorming session as much as it will be an interactive process. So you may be brainstorming as to what's available, what's possible. That does include encouraging the individual to seek vocational rehabilitation services from the state VR agency. The Texas Workforce Commission now houses the state's vocational rehabilitation programs, and people with disabilities are eligible to go and apply for those programs. And certainly, if they meet the criteria, they're eligible to get adaptive devices for them to go to school. They could be eligible to get assistance such as live, to pay for a live reader to read to them when they're doing their homework. So there's all kinds of things that are possible when it comes to providing accommodations. But being able to participate in this interactive process, in a helpful way will definitely go a long way towards toward making this an easier process. Slide 23. Are there any questions at this point?
Oh, here we go. They're saying, I'm not sure if this is an appropriate question for this particular training, but can you provide guidance or information related to service pets? Who regulates or licenses service pets or service animals? Is there a national registry? How can entities ensure that a service animal is a legitimate accommodation? Thank you.
Sure. That's a great question. Thank you for asking that question. It reminds me to bring things back a little bit to some of the, more basic routine type of accommodations that we all see, possibly more often than not. And people being accompanied by a service animal, usually a dog, is a very common type of accommodation for people who attend school, okay? Whether they're going to adult literacy classes or whether they're going to college courses, whether they go to class every day or once a week. The ADA protects their right to be accompanied by their service animal, so long as the service animal meets the definition of service animal under the ADA regulations, which applies to both public entities as well as public accommodation private entities. So essentially, a service dog, has to provide some kind of a physical function for the person in order for the person to be protected and be allowed to be accompanied by their service animal. Now, notice how I'm emphasizing service animal and not pet, because service animals or service dogs are not pets. So you have to refer to them as service animals, assistance animals. There's like sort of an interchangeable set of terms out there, but under the ADA, the regulation calls them service animals. And then when you read the details of the regulation, you get to learning that there's only two types of animals allowed to be a service animal, quote unquote. One is a dog of any breed or size, and the other could be a miniature horse, okay? A miniature horse. Now, miniature horses are so rare, at least for now, although I think they're becoming visible in some cases more than a few years back. But nevertheless, miniature horses come with a limitation built into the regulation itself that basically say that, a miniature horse will be permitted to act as a service animal, provided that the environment allows that to occur. Okay, so there may be environments where a miniature horse may not be permissible, and we can talk more about that offline if you have any questions about that.
We've got one more.
Sure.
Go ahead. Sorry.
Yeah. No, I was just going to say we've gotten a few questions about those in the past here at the ADA Center, but not as many as one would think. Most of the questions relate to service animals and service dogs. So I just want to make one differentiation. Remember, there's service animals protected by the ADA, and then pets are not protected by the ADA. Typically, emotional support animals or emotional support dogs are not protected by the ADA. Okay. In Texas, however, the legislature passed its own rule, and they made it broader. They made the definition broader, and it includes PTSD dogs. So people who come with a prescription for PTSD and they have an animal for PTSD are allowed to enter a public place such as a classroom. So we can discuss that more offline. And so those are some of the differences that you should be aware of. And then again, you're allowed to ask some questions to make a determination. The one question you can ask is this dog necessary because of a disability? And the second question is, what does the dog do for you in terms, in connection to your disability. No other questions are permissible. So you cannot ask the person to demonstrate what the dog does for them, or have the dog demonstrate what services it provides for the person. Again, if you read the definition, you get more details. And basically what we're talking about is animals that provide a physical function, such as being a guide dog for a blind person, a hearing dog for a deaf person, a dog that is capable of detecting seizures or epilepsy occurrences. There's psychiatric dogs that help people take their medications or prevent harmful or destructive behavior. So those are going to be ADA protected service animals that are typically allowed to accompany the person into a public place. Okay, next question.
Okay, one more question. It says, we had a student with a spinal injury who was wanting us to regularly provide him assistance with going to the restroom. What would be an appropriate response for that?
Well, remember that I don't think I have it in the presentation actually. I think I might have it in the previous presentation during webinar 1 that we did. And as Anne-Marie mentioned, it'll be made available to you guys. Basically, that there are certain types of accommodation requests that do not have to be honored. In other words, they don't have to provide, for example, they don't have to provide personalized services, which is what this question sounds like. It sounds like the person is asking for a personalized or personal service, and essentially neither public entities nor private entities are obligated by the ADA to provide personal, quote unquote, personal services or devices or assistance for the individual in terms of, carrying on their lifestyle or meeting their disability related needs. So providing assistance to go to the bathroom would be a personal service, and they have no obligation to provide that assistance. And it's best to have this discussion with the person again in private when they're asking for the accommodation, and informing them that that is a personal service, and they need to encourage that individual to retain their own personal care attendant, which they can do either through the Vocational Rehabilitation Services Program, or they can obtain on their own if they go talk to people that work in those areas and provide, personal PCAs, personal care attendants. It is sort of a business and industry out there, and they can be easily located and found. The question is whether the person will be able to pay for those costs out of pocket, or whether through their coverage through Medicaid, for example, or their whatever other health insurance they might have, or whether they can become eligible to get PCA assistance from a vocational rehabilitation program. And many people have been able to achieve that. Many people have very significant, severe disabilities with medical needs 24 hours a day around the clock, and they do need personal care attendants. And so, again, those individuals should be encouraged to, obtain their own personal care attendants, because the public entity and the private entity, neither one is obligated to provide personal services.
Okay, and their response also to your question was that was pretty much what we did. He did just sort of spring it on us the first time, though.
It does happen that way sometimes. Like I said, remember, a lot of people come with a disability, but they may not necessarily be versed in how to deal with it when they are going into a public place or going to school. They may not be entirely experienced in addressing their issues. So there's going to be a time of learning and experience, and hopefully the individual will be cooperative and be willing to go the distance, and become resourceful in terms of obtaining their own personal support.
Okay, I think we're right at 3 o'clock, Diego. So I think we're
Okay.
ready to move along to
Okay.
illustration 1, and that's where I come in.
Yes. Illustration one.
Illustration 1. So a community civic association arranges to provide interpreting services for a deaf individual in wishing to attend an adult literacy class at a local community center. The interpreting service requires the organization to provide payment in full prior to each class. Due to a personal emergency, the individual is unable to attend one class. The organization may not charge the deaf individual for the cost of the unused interpreting services.
So this is a very quick learning lesson. We get many questions about this, and the question, of course, translates to whether or not the entity can assess a fee or a surcharge with regards to services that remain unused or accommodations that cost money and remained unused. And the answer is no. In order to put a stop to an abusive situation, because this example talks about a person having, some kind of emergency and they just couldn't be there. So certainly the entity cannot pass the bill over to, shift the bill over to the person with disability just because they didn't show up for one time. So unfortunately, we have gotten calls, that told us where the facts were that people were missing various appointments, like with doctors, for instance, missing appointments, and essentially the interpreter was there to interpret the visitation, but nobody shows up. And we've had instances where we were told that people have done this on multiple occasions. And true or not, we provide them with the neutral technical assistance that we can give them with regards to how to establish a policy to deal with this. And the only policy that you can have is that if you determine that there's a pattern of abuse, then you would treat it no differently than you would treat any other patient attending your, going for medical services. If they keep missing appointments and your policy is to assess a a no-show fee, then you can assess that no-show fee, but you cannot charge the cost of the interpreter service. And of course, if it happens, multiple times, then you may have to start considering other measures, because while you cannot discriminate against a person with a disability, you can certainly impose rules to make sure that the problem doesn't keep occurring if the person is obviously doing it on purpose. So you would be within your rights as an organization to try to figure out how to solve the problem, equitably and amicably and fairly, But basically, the Department of Justice has said that in general instances where people just couldn't make it because they were sick or they had an accident or some such, then they cannot charge those accommodation fees. Next illustration.
Okay. So going on to the next illustration, an AEL program provides a reader for an applicant who is blind who is taking one of its AL courses. But the reader is unfamiliar with the material and mispronounces words. The blind student misunderstands the reader when she's taking a test. AL Center is not in compliance with the ADA because the necessary communication for the blind person is not effective, and the blind student is instead tested on the extent of her disability and not the learned knowledge of the course.
Okay, so again, this is a fairly quick lesson, and I can certainly identify it because I'm visually impaired myself, and it's interesting. A lot of people who give tests, test proctors and organizations that give testing, like professional testing and so forth. They don't understand, they don't realize that reading the test is extremely important, and being able to comprehend what's being read is extremely important, to the extent that if the reader reading out loud for the person who's blind or visually impaired is mispronouncing words continually and cannot read grammatically correctly, in other words, interpret grammar correctly, then basically what's being tested is the person's disability, the blind person's inability to read printed text, not the material being tested. And I think that should be pretty obvious to a lot of people. And again, this is just one of those accommodations where you have these subtle issues that tend to come up. And this is why I always recommend that people who deal with blind or visually impaired students, or they come across or they get a request from a blind or visually impaired student, is that they always ask, how do you do your studying? What have you done to study? What adaptive devices do you use? And you're going to find that in this day and age of technology and human-sounding computer voices, a lot of people are using devices to do all of their reading as well as writing, and they can get by pretty well on their own without even having accommodations other than requesting extra time on taking examinations. Because remember, when you're using an adaptive device to do your reading, the time it takes to read will be longer. It will not be the same time frame that a sighted person takes up when they're reading and they're able to scan with their eyesight. They can read and scan back and forth. It's a very quick process. Whereas blind and visually impaired people have to rely on the audio to listen, so the timing will be totally different. And again, there have been people with vision impairments who want time and a half, and other people who prefer twice the amount of time, or even 3 times the amount of time of the regular testing time, depending on the nature of the examination. The more difficult the exam, typically the more time a blind student will request to take the examination. Next slide. So we have defenses, fundamental alterations, we have undue burdens, and I said to the person that asked the question earlier that we will be discussing this in a little bit more detail, so I'll try to be as quick as possible. So essentially, if and when an entity is unable to provide an accommodation because it is unduly burdensome, expensive, costly, difficult to put together, or maybe the building itself is so inaccessible that making it accessible would be beyond reasonable, costs of making it accessible, then they still have an obligation to try to work with that individual with a disability and try to figure out a better way or an alternate way to provide access to the course material or to attend classes. Next slide. Here's the undue burden factors. As you go through this, you can see that meeting the undue burden defense. Remember, these are defenses. Defenses means that the entity can use these reasons as a defense to say, no, we cannot provide you with this accommodation. Or no, we cannot make this modification. Or no, we cannot install the ramp because it means a major construction undertaking where we have to take down beams and break down ground and break down walls, and the cost would, be so substantial that it would fundamentally alter the nature of the business itself or the class being taught. In other words, it'll eat up into the money available to run it. So, but again, look at the factors on this slide, which I've given you here. It's dense. You don't have to memorize this. Just have it available for reference when you need it. So you understand that many factors can go into proving that you meet this undue burden defense. It's not so easy because it's going to take into consideration the size of the entity. So for example, suppose you have a nonprofit entity that has many, many different grants for which it produces different kinds of programming. Classes, activities, community activities, it could be doing different things for the community, including an adult literacy program as one of its many different activities that it does, okay? So suppose that they want to hold an adult literacy course at a location where it may not be accessible and they might need to install a ramp to access to go through the front door. Well, the undue burden factors are going to look into the size of the organization, the nature of its business, and what is typically going to happen is that it is not going to be there may not be a foundation to claim the defense of undue burden. There may not be enough. In other words, installing the ramp may not be so unreasonable that they can't afford it, or at least plan for it to be installed in the short term. So these factors are important to look at and to think about. And if you have questions about these, feel free to call us online or just send me an email, and I will be happy to expand more on how to use these defenses. Again, slide 28 is undue burden factors continued. So we move on to the next slide.
And I believe we're opening it up for some questions.
Some questions, yeah.
Do we have any questions from our audience at this time? Please do. Oh, there's one. Please, reminder to type it in that chat area if you have a question. What happens if the property to be modified is not ours?
Yeah, basically, well, first, let me be cold about it. The ADA doesn't care whether the property is leased or owned. What it cares about is whether or not what's happening at that site is ADA accessible or ADA compliant. And so basically, private entities or even public entities are allowed to negotiate with the owners of the property as to who gets to comply and who pays for any ADA-related modifications. So, but essentially, if a complaint were to be filed, then the people that would be held responsible by the Department of Justice would be the people who run the organization or the business, the people who are leasing the place. So the responsibility is always on the shoulders of the people who run the educational program or who run the business. Likewise, with public entities, it falls on the shoulders of the public entity to make those locations accessible. Even if they are renting a site from a private landlord, they still have to make the programs accessible. And again, remember, public entities have a slightly different set of more increased obligations, or what they're otherwise known as overarching obligations, okay? In that they have to make all of their programs generally accessible, meaning that while one site may not necessarily have to become accessible, they will have to provide the same services or programs elsewhere at a convenient location for a person with disability to go there instead. For the private entity, it's different, because for the private entity, it doesn't have that kind of overarching obligation. Its obligation is to basically consider readily achievable barrier removal. And that means that so long as it is not significantly expensive or costly, then they are required to engage in making the modifications, even if they're structural modifications, such as widening doorways. Those always tend to be reasonable. Widening doorways, putting accessible door handles on the doors, even installing an automated door opener. All those things tend to be reasonable, and they don't typically go into the expensive, side of the column of expensive things that might be defensively, burdensome, or that might cause such a financial hardship that it would fundamentally alter the nature of the business itself. Okay.
Okay. I think we might be done with questions for now. Just a quick reminder,
Okay.
If you do have them, submit them there in that chat area, and we will get them at closing. We have about 15 more minutes, Diego.
Okay.
Moving on to fundamental alteration factors.
Yep. Fundamental alteration, again, is another type of defense, and it basically means what it says. If it's something that's so significant, would affect the nature of the class being taught, for example, then that accommodation, should not be provided, because the ADA does not require an entity to either go bankrupt or to close its doors or to not provide the service or the class. In the case of adult literacy programs, the ADA does not require them to close doors and not do it just because it might be inaccessible or because an accommodation cannot be provided. Again, though, they have to show evidence, proof of why a requested accommodation or structural modification to make the place accessible would be so fundamentally altering. It's just not. It's not a presumption that they claim the defense and therefore it's done. They have to be willing to, in writing, offer and delineate an explanation how such a requested accommodation or modification would fundamentally alter the program. And that would mean discussing the monies being spent, discussing the nature of the program and how the budgets are allocated. It would require quite a bit of detail to explain this to someone who might actually threaten to file a complaint. They might be willing to say, show me why, and I'll decide whether to file a complaint or not. And you may be called upon to show them why, which is why I always recommend that private entities create detailed documentation for their file, even if the person is told, we're not going to be able to accommodate you. We cannot make these building modifications, not until next year, so on and so forth. And the person leaves and never comes back. You never hear from them again. Well, even so, you really better have some really good documentation on file with regards to that one individual. And this is to prevent, confusion and arguments and frustration in the future should the person decide to file a complaint. Okay, next slide.
And
illustration.
Illustration 4 or 3, sorry. I jumped ahead there. An adult literacy program hosted by a small nonprofit organization makes available a sign language interpreter for one of its classes every Tuesday at 7 p.m. The availability of the weekly class with an ASL may be a factor in determining whether it would be an undue burden to provide an interpreter for a deaf person who wants to attend classes set for Saturday mornings instead. The entity would need to consider moving the ASL to Saturday. The ASL program may not need, the ASCL program may not need to hire a second ASL to cover both scheduled weekly classes.
Okay, so apologies ahead of time if this illustration seems rather confusing, or I didn't mean it to be confusing. So hopefully, if I use this again, I'll try to clarify it better. But essentially, you see what's happening here. We have, let's presume we have a nonprofit organization making available an adult literacy program, and essentially, it has decided to contract with an ASL provider. Now, understand that when you retain ASL services, you might be able to save money when you contract them, when you retain them to come in and do work more than just one time, meaning you're going to use them again and again. And so if you have a program providing adult literacy classes, let's say for, 3 months, okay, twice a week, like this fact pattern shows, like this illustration shows, then, you may not be able to afford having a sign language interpreter twice a week on 2 different times, just automatically there, regardless of whether people who are deaf show up to use the services or not. Typically, I would say, until you get a request, you don't have to provide a sign language interpreter. I mean, that is the nature of a requested accommodation. If it's not requested, it is not provided. That is a given rule. Okay, so don't think that because this illustration shows that they have an ASL coming in once a week routinely, that this is how it has to be. That's not it at all. Okay? What this illustration shows, or what I was aiming to show, is that if there is financial hardship, if there is undue burden to be considered here, and you have people who are deaf and hard of hearing who want to attend the course, you've been notified, or they contacted you, or whichever applies, then you can schedule the ASL to come in, and then you will make announcements. You could make flyers and make announcements and announce that a given class on a schedule will have a sign language interpreter available to interpret for people who are deaf or hard of hearing and who can use ASL. Okay, so keep this in mind, because what this illustration also shows is that you can do this to provide this kind of expensive accommodation, or rather auxiliary aid, right? Because this is what this is. It's a communication accommodation, remember? So it's an auxiliary aid or service, in this case, the service. You can make it available, let's say, on Saturday mornings, and invite people who are deaf and hard of hearing to come in for that class, along with everybody else, if they want to do that. Obviously, you have other considerations if you want to provide the accommodation in that way. One of those considerations is that if you only get one deaf student to sign up, for example, and they can't go on Saturdays, but they can go on Tuesday nights, then you may be called upon to move the ASL schedule to Tuesday night. That would be a reasonable accommodation. That would be a reasonable arrangement to make instead. And then again, you would, given enough time, you would be able to advertise that and promote it as being accessible for deaf individuals on that particular night on that schedule. Again, all these things are very, very, you can discuss this. You can come up with different ways to provide these accommodations. But again, remember that unless you get a request, you do not have to provide an accommodation, no matter what it is. Okay? Architectural barrier removal in facilities is a different situation, because there are many people with disabilities who don't request any accommodations. They expect to be able to go there and sit in for the class and then go home like everybody else. And guess what? A lot of those people use wheelchairs, or they might be ambulating on a walker. So you need to understand that the architectural barrier removal for facilities is an ongoing ADA obligation, and there are no grandfathered properties. Nobody is exempt from removing readily achievable barriers that can be removed. Okay? Again, that's a standard, and we can discuss it, but I did discuss it, I believe, in more detail during the first presentation, so you can go back and look at readily achievable barrier removal, or you can look it up. If you want to use the checklist that we developed for existing facilities and barrier removal, you can go to adachecklist.org. That's adachecklist.org. It's free of charge, and they're downloadable documents, PDF and Word document, and they're fillable forms. They allow you to review an entire property from top to bottom for barrier removal. Okay.
Diego, we do have a couple of questions, and very quickly, because we're about 7 minutes till.
Yeah.
We do have a couple of questions. First one is, we should have clarified this. Yes, American Sign Language, ASL stands for American Sign Language.
Thank you.
For anyone who we had that come in earlier. But can you clarify that the ASL interpreter does not need to be in place until it's requested? Is that correct?
That is entirely correct, yes. And remember that people with disabilities have an obligation to make accommodation requests on a timely basis, okay? But you must understand that even if they come late on the day or the night before the classes are due to begin, okay, they are still going to be entitled to reasonable accommodations. So just because they're late, that does not make them ineligible for accommodations. So, unfortunately, with regards to providing interpreters for people who are deaf or hard of hearing, it becomes more difficult because many interpreters, or depending on where this is located, whether it's a big city like Houston or a small town, there may not be interpreters available on a short notice. There may not be any available period in town. So other consideration would have to be undertaken. But nevertheless, yes, an accommodation, the bottom line is that an accommodation does not have to be provided unless it is requested by an individual student. Okay.
Okay. This next question is: can we ask for any requests to be in writing, or do we have to accept verbal requests?
It's nice when people submit them in writing, especially when it would be more complex than not. But unfortunately, there's no ADA obligation upon people with disabilities that they submit requests in writing. They as long as they make a request orally or by telephone or by email, they have made an ADA request for an accommodation. So now, certainly, you're entitled to take notes and to write down and create a record of the requested accommodation. And you can even verify it. You can even, you could say, okay, so you're asking me to do A, B, C, and D for you as an accommodation. Let me verify this with you later through an email. What's your email address? And you would certainly be doing really good due diligence in keeping records for the people that you accommodate. In keeping records of the people that you accommodate, along with their names, because you want to have a record of people that you're accommodating individually. The colleges, universities, they all keep very detailed records. They even have forms for people to fill out. So you're welcome to have a form if you want people to fill it out. Just remember that, again, there's no ADA obligation imposed on people with disabilities that they even use a form. And certainly think about the fact that if you're teaching an adult literacy program, they may not be able to write very well. So, and also, many people who are deaf or hard of hearing, English is essentially a second language. It is not their first language. So be aware that your organization may be getting an incoming request for a sign language interpreter via a TTY machine through a phone call or via relay services from the state. You might get a phone call. Be very aware and very open to receiving relay phone calls from people who are deaf, because they happen very, very often. And we get a lot of complaints at the ADA Center by people telling us that organizations have not been answering their telephone, or they've been hanging up on them because they don't understand what's happening, or because they think that just because they're talking to a relay person, that the conversation is not confidential and private. And let me clarify this. This is really, really, really ultra important to keep in mind when you're teaching school, okay, of any kind. People will very often disclose confidential information such as social security number, dates of birth, okay? If the deaf person is talking through a sign language interpreter or a relay service interpreter, that conversation is private and confidential. In other words, just because there's a third person in the middle, the intermediary, who is facilitating the communication, that does not mean that confidentiality has been broken. So please don't do that to yourselves, and simply treat people who are deaf and hard of hearing calling through relay, treat them as you would any other person calling you on the telephone, including providing credit card information, payment information, SSN numbers. Again, treat them like any other person, and apply the same rules that you apply to anyone else when you're dealing with confidential information. Okay.
Diego, this is Anne Marie. We do have another question that's been in the chat pod for a while, and it's from, and this person asks, what is a reasonable amount of time to get the accommodations in place? And we have about 2 minutes, or actually 1 minute.
Sure. Basically, there's no definition for a reasonable amount of time, quote unquote. You take people as they come with whatever disabilities they come with. And if they show up late, then you're within your purview to explain to them that the accommodation arrangements may take longer and that they may be attending classes without those accommodations. You explain that you will do everything within your power to make things happen, but it doesn't always work that way. And if people are not willing to understand that, then truthfully, there's not much or anybody else that anybody can do about that. So reasonable means reasonable. People requesting more complex accommodations, such as a sign language interpreter, they have been trained. Many have not, to ask for things way in advance, a couple of weeks in advance, 4 weeks in advance, and also remember that the information for the class needs to be posted. It needs to be available ahead of time. So if it's only made available on a week's notice, well, then everybody has that much time to request accommodations, or at least until the first day of class. Many students wait until the first day of class. They wait to go to class, they experience the class, and then they decide, okay, I need, a couple of things, and they go and talk to the teacher. Other students will do things ahead of time, so there's no way to know. But again, reasonable means reasonable. And even if they are extremely late, they're still entitled to accommodations, even if it's halfway through the semester and they still choose to attend and register and they want the accommodation, you'll still have to work at obtaining that accommodation.
Okay, I think we're out of time, Diego.
Okay.
We've got it on your takeaways slide.
Yeah, the takeaway slide. I think we've been through all of this. We'll skip the illustration 4. People are, welcome to call us. And so we're not going to go, over the takeaways. I think everybody understands what we just went through, and they can review this offline once it becomes available. And I just want to thank everybody for listening to me. And again, please call me directly. I will be more than happy to talk to you directly, myself, and I'm available for, all kinds of questions and whatnot, and policy guidance and so on.
And we do have your contact information up there. Just very quickly, 1-800-949-4232. That's our telephone number. Feel free to contact us.
I'd like to just thank everyone for your participation and all of the great questions. We did run a little bit out of time, so I'm wondering, Diego, if there are other questions that people want to ask. You are free to roll off since it is 3:30, but if there's other questions for the next couple minutes, if there are questions, we will stay on. And if not, thank you again, everyone. And I want to remind everyone that the next ADA webinar is on March 29th at the same time. Thank you so much. Thank you so much, everybody.